request Dr. ALAGUMANI to welcome address.
On behalf of the Orientation Committee, we welcome all who present here in this evening. Our beloved President, Mr. ANDIRAJ sir, our Secretary, Mr. ANBARASU sir, our Coordinator, Mr. Petraj sir, Organizer, Karnanidhi, the office bearers, Orientation, and beloved advocates. Our beloved advocate, born on 1965, I enrolled as advocate in the year 1988. It's the first batch of 5 years law course from our Madurai Government Law College, a classmate of my beloved senior Mr. T. Lajapati sir, and Prabhu Rajdurai sir, and several advocates practicing here. And sir completed Master of Law degree from Madras University. After his Master of Law, served as a assistant professor in Salem Law College. Thereafter practiced in our principal seat. And from the inauguration of this Honorable Madurai Bench of Madras High Court, sir is practicing here. Our senior advocate is the first founder secretary of our Madurai Bench, MBHAA, first founder secretary. And welcome sir. And served as a president of this prestigious association. Sir is a all-rounder. Sir, bowler, batsman and fielder, practicing in all fields and practicing in this Honorable Court, Madras High Court, and also before the Honorable Supreme Court of India. First sir started his practicing under Mr. Senior Advocate Mr. G. Masalamani sir, who was the former Advocate General of the state of Tamil Nadu and first Additional Solicitor General for South India. Then sir started practicing with Mr. K.S. Ahmed sir, who was a former government pleader of Pondicherry. Sir designated as a senior advocate in the year 2012, practicing in all branches of law. And sir, having in-depth knowledge in all branches, he is not only a designated senior advocate, he commands respect from all sections of our community. To the best of my knowledge, a large number of reported citations or for the judgments are from the contribution of our beloved senior advocate. Once again, I welcome our beloved senior advocate on behalf of our Orientation Committee and MBHAA. I once again welcome one and all who are presenting here for this orientation program. Thank you.
Now I request our dear President, Mr. ANDIRAJ, to give the presidential address.
நமது மன்றத்தின் சார்பாக மூத்த வழக்கறிஞர் திரு அஜ்மால்கான் அவர்களை வரவேற்பதில் உங்களுடன் சேர்ந்து நானும் பெருமைப்படுகிறேன். ஏன்னா அவருக்கும் எனக்கான தொடர்பு இப்போ இல்லை, 2004 அவங்க அழகுமணி சார் கரெக்டாக சொன்னாங்க. ஒரு ஃபவுண்டர் செக்ரட்டரி மட்டும் இல்லை, அவர் பேருக்கு செக்ரட்டரி இல்லை. எல்லா போராட்டத்திலையும் நம்மளோட சங்கங்கள் அனைத்து போராட்டத்திலையும் அவங்க இருந்திருக்கிறாங்க. அது அவரோட ஒரு பாட்டு. அது மட்டும் இல்லை, நமது சங்கத்தின் சார்பாகவும் சரி, உறுப்பினர்களுக்கு ஏதாவது ஒரு பிரச்சனைன்னு போய் நிற்கும்போது சிரித்த முகத்துடன் உடனே உதவி செய்யக்கூடிய ஒரு அருமையான நண்பர். முதல்ல அதை நம்ம மறக்கவே கூடாது. நிறைய பேர்த்துக்கு போராட்டத்தில் மட்டும் இருப்பாங்க. சாருக்கு 2 பக்கம் உண்டு. ஒரு பக்கம் இந்த குணம், இன்னொரு பக்கம் அழகுமணி சார் கரெக்டாக சொன்னாங்க. அவர் சீனியர் கவுன்சிலர்ஸ் ஹேவிங் எ சவுண்ட் நாலேஜ் இன் ஆல் டிஃப்ரெண்ட் ஃபீல்ட்ஸ். அவர்கிட்ட ரிப்போர்ட்டட் ஜட்ஜ்மெண்ட்ஸ் இல்லாத ஜட்ஜ்மெண்ட்ஸே இருக்காது. அது மட்டும் இல்லை, இந்த மதுரை கிளை 2005 ஆரம்பிக்கும் போது எல்லாருக்கும் இது ஒரு செகண்ட் பெடல் மாதிரி இருந்தது. இன்னைக்கு அது மாறி நம்மளும் அவங்களுக்கு சளைத்தவர் அல்ல என்ற நிலைக்கு வருவதற்கு அவருடைய பங்கு மிகப்பெரியது. மதுரைக்கு நான் போனவங்கள கேட்பாங்க, அஜ்மல் சார் எப்படி இருக்காருன்னு. ஏன்னா மதுரையும் மதுரை கிளையும் அஜ்மல் சாரையும் பிரிக்க முடியாது. அந்த அளவுக்கு தன்னுடைய முத்திரையை அழுத்தமாக பதித்தவர். இன்று நம்முடைய இருக்கிறார் என்று சொன்னால் அது மிகப்பெரிய பெருமை. அவருடைய அனுபவத்தை நாம் அவரை தொந்தரவு பண்ணி அவருடைய அனுபவத்தையும் அவருடைய அறிவையும் நாம் பெற்றுக்கொள்ள வேண்டும். அதான் நான் யங்ஸ்டர்ஸ்க்கெலாம் ரொம்ப கேட்டுக்கிறது. இது லெக்சர் நம்பர் 4. இது ஒரு அருமையான சந்தர்ப்பம் அனைத்து இளம் வழக்கறிஞர்களுக்கு. ஏன்னா நாளாக தாண்டி தான் வந்திருக்கேன். ரொம்ப கஷ்டப்பட்டு லைப்ரரியில் போய் படிச்சுட்டு இருப்போம். அந்த லாங்குவேஜ் எல்லாம் சரியாக புரியாது. ஒரு தடவைக்கு 10 தடவை படிக்கணும் ஸ்டில். பட் அதை வந்து ஒரு சீனியர் கவுன்சில்ஸ் நம்ம எக்ஸ்பிரஸ் பண்ணி சொல்லும்போது வி ஈஸி டு அண்டர்ஸ்டாண்ட். ஐ ஹோப் தட் all the juniors let us use this great function. Thank you once again.
Now I request Mr. ANDIRAJ President to felicitate our chief guest Mr. Senior Advocate Mr. Ajmalkhan by attending the shawl and book. Now I request Senior Advocate Mr. M. Ajmalkhan to give a special lecture in topic of Uniform Civil Code.
Mr. ANDIRAJ, the President, Mr. ANBARASU, the Secretary, and Mr. Petturaj, Treasurer, Mr. Dr. ALAGUMANI, the Chairman of Orientation Committee, and other office bearers of Madurai Bench High Court Advocate Association, the learned advocates, my friends across the bar. Good evening to you all. I am very glad to join with you this evening on this august body on the debate of Uniform Civil Code. The debate on Uniform Civil Code is not new. There had been and there has been a debate on Uniform Civil Code pre-independence era, post-independence, pre-constitution and post-constitution era. And this debate is now necessitated because a private bill was introduced in the Rajya Sabha last week for constitution of the committee for enactment of Uniform Civil Code. And that is the reason why the Chairman of Orientation Committee has chosen a debate on the Common Civil Code, that is Uniform Civil Code, and has chosen me as a speaker. If you see, the Britishers left us to have a debate only on the Uniform Civil Code because we have a common criminal law code that was enacted by the Britishers even before our independence. We have got Indian Penal Code 1860, Criminal Procedure Code 1908, Indian Evidence Act 1872. A common criminal law applicable irrespective of religions for the citizens of India have been enacted by the Britishers before the independence. But in so far as civil law is concerned, there is no common civil code. There was people prior to independence have followed their own customs, usage, their respective personal laws. And the Britishers have thought not to enact a common civil code for all religions, all citizens irrespective of religion. They pursued the difficulty. They pursued the difficulty in the sense they didn't want to disturb the harmony that India is enjoying. If you see, unlike other countries where they have homogeneous community, in India the community is at large or heterogeneous. There are so many religions, so many castes, so many languages, so many cultures. That is the reason why we call India unity in diversity. If you could see TMA Pi Foundation case, 11 judges bench, para 158 of TMA Pi Foundation case, they have given some statistics. The statistics are, in India, according to Supreme Court, there are 6 main ethnic groups and 52 major tribes and 6 major religions, 6,400 caste and subcaste, 18 major languages, and 1400 minor languages. That is India. That is what they recorded in para 158 of judgment of the Supreme Court in TMA Pi. If you could see, you can find those statistics. Can we have a common civil code in respect of all those peoples? All those people in India, they follow their own culture, they speak their own language, they follow their own faith. That was the encounter that is faced by the people who are at power, not only now, but also pre-independence era. The debate on Uniform Civil Code was there even prior to independence, as I said. In March 1947, that is before our independence, there were committees constituted by us. The committees on fundamental rights, the committees on minorities, and they had a discussion, they had a debate on Uniform Civil Code. The committee on fundamental rights, the members are Dr. Ambedkar, Munshi, Alladi Krishnasamy Iyer, and they debated and they enunciated the enactment of a common civil law that is applicable for all citizens irrespective of religion. There was a proposal in the subcommittee on fundamental rights. Earlier the proposal was made by the subcommittee to have the proposal for the enactment of Uniform Civil Code for all religions in the fundamental rights. March 1947, before our independence. And the proposal was turned down by the committee, and the members of the committee has proposed, said earlier that was the fundamental right as given under part 3 now was there under chapter 1 and in the subcommittee. The subcommittee has said we can move the proposal for the enactment of common civil code from chapter 2, directive principles of state policy, prior to the enactment of our constitution. Now it is in part 4, you know. From moving the proposal from chapter 2 to chapter 1, there was a widespread protest by the members. One of the member, Masana, he said there is a application of civil laws to people on different faiths, different personal laws on different people ruins the country, and there is a watertight compartment in the country applying the personal law to each and every subjects, and it should be avoided, it should be put an end, according to that Masani, speaking in the subcommittee on fundamental rights. And if you see Dr. Ambedkar, I was thinking that he would be against the enactment of the common civil code, but I have gone through the report of the subcommittee on fundamental rights, subcommittee on minority rights, and the debate on the Constituent Assembly. Dr. Ambedkar was vociferous in the enactment of the common civil code, and the reason I will divulge now. And secondly, in the subcommittee on minorities, that is prior to our independence, they said, they have discussed, they have debated and they discussed, and they say no doubt there can be a provision for enactment of common civil code, but it should be voluntary. It should come from the people voluntarily, and it should not be imposed on the people as compulsory. That was the decision taken by the subcommittee on minorities, that is prior to independence. Now let us come to Constituent Assembly after independence. In the Constituent Assembly, there were debates in 1948. As you know, there were our constitutional makers under the chairmanship of Dr. Ambedkar took 2 years, 11 months and 18 days for enactment of our constitution, for drafting of our constitution. Each and every word has been discussed by the drafting committee, and they took even for months together for discussing about a word. Even I can tell you, the word minority as found in Article 30 Clause 1 of the Constitution of India was discussed by the drafting committee for 1 month. Whether such a word can be identified or some other word, certain section Some people have suggested instead of minority we can say certain section. Ultimately minority was approved. Similarly, each and every word was discussed, debated in the drafting committee under the chairmanship of Dr. Ambedkar. Ultimately, after 2 years and 11 months and 18 days, our constitution was drafted. In the Constituent Assembly, most of the members, including Dr. Ambedkar, Allah Krishnasamy Ayyar, Munshi, they were for enactment of Uniform Civil Code. Whereas Ismail Sahib is none other than Qaide-e-Millat, which we popularly call in Tamil Nadu. And the title of Qaide-e-Millat was given by I think C.N. Annadurai or Periyar. And he spoke in the Constituent Assembly. He was one of the member of the Constituent Assembly. He said it should not, the minorities should feel that they are secure in India, and therefore it should not be imposed on the minorities compulsorily to follow Uniform Civil Code, and it should be on voluntary basis. And his argument was supported by Nazaruddin Ahmed and Mahmood Faruqi, who are also members of the Constituent Assembly. Ultimately, and provision has been made, not under Article 44 of the Constitution of India, making Uniform Civil Code as directive principles of state policy. You know, we have Part 3, Part 4. Part 3 speak of fundamental rights which are enforceable in the court of law, and the state is bound to follow. Whereas the Part 4, which contains the principles of the policy of the government, it can't be enforced in the court of law. It is for the state to consider, state to enact certain legislation to give effect to the directive principles of state policy inherent under Part 4 of the Constitution of India. And therefore, Article 44 was included in Part 4 of the Constitution of India, which contemplates the state shall endeavour to secure for citizens Uniform Civil Code throughout the territory of India. That is what the wording employed in Article 44. The state shall endeavour to secure all citizens Uniform Civil Code throughout the territory of India. The article does not say the state shall secure Uniform Civil Code for citizens throughout the India. The article says the state shall endeavour. There is a difference between the state shall secure and the state shall endeavour to secure. If you see the word endeavour in the Black's Law Dictionary, it says it is an attempt and trying something intellectually, to do something. That is what the word endeavour is defined into the Black Laws Dictionary. And therefore, the Article 44 that is framed by the lawmakers, our founding fathers of the Constitution, contemplates the state shall endeavour to secure citizens Uniform Civil Code throughout the territory of India. We have Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Adoption and Maintenance Act 1956, applicable for Hindus. We have Christian Marriage Act 1872, Indian Divorce Act, Indian Succession Act, applicable for Christians in the matter of marriage, divorce, succession, inheritance. Similarly, for Muslims, we have Muslim Personal Laws, within bracket Shariat, bracket closed, Application Act 1937, and the Dissolution of Marriage Act 1939. So we have our personal laws applicable to different faiths, Hindus, Muslims and Christians. And the Article 44 contemplates enactment of Uniform Civil Code irrespective of religion for the citizens of India throughout the territory. Why the throughout the territory has been mentioned is, I would like to bring to your notice, there is a common Uniform Civil Code for the subjects in one state, the state of Goa. You know, state of Goa was originally ruled by Portuguese. They enacted uniform civil code for the people who are living in Goa. That still holds good. They have no personal laws. That was not done by the British. Taking into account of the geographical, religious, linguistic concepts, the British have not framed the uniform civil code. It left to the will of the people. Once the freedom is given, the freedom is now given to us. Now shall we move on acting the enactment of common civil code, or let us maintain the status quo as on today? That we will have to see. I can take you the role of judiciary. As I said, it is the directive state policy of the state to enact uniform civil code. As and when some issues have been raised in the past for the enactment of civil code, there rise a hue and cry that it cannot be done. If done, it will create a communal disharmony among the people, and there will be a unrest among the people, and therefore such exercise should not be adopted. In so far as judiciary is concerned, for the first time in India since independence, one of the first Bombay High Court encounters the issue of common uniform civil code. That was the first time, not the Supreme Court but the Bombay High Court. In Bombay High Court, first Indian Chief Justice of Bombay High Court, you know, Justice Chakla, was the author of Roses in December. You can read that autobiography. It was a very good autobiography ever written in India. Justice Chakla. Justice Chakla as Chief Justice, sitting along with Justice Gajendra Garkar, who later became the Judge of the Supreme Court. And they have considered the issue regarding the validity of Bombay Hindu Prevention of Hindu Bigamous Marriages Act 1946. They rendered the judgment in 1952. Act was challenged. Judgment was rendered in 1952 after independence. In the said judgment, the act prevents Hindus in Bombay, that is in Bombay presidency, from contracting second marriage when the first marriage was subsisting. That was challenged before the court. It offended Article 14, 15 and 15. Such law does not prohibit the second marriage by Muslims. That was the argument advanced before the court. And it was also raised before the court that the law 1946 Act is inconsistent with Article 13. You might be knowing Article 13. There are two clauses in Article 13. Article 13 falls under Part 3 of the Constitution of India. 13 Clause 1 says, if any law for the time being in force on the date of commencement of the Constitution, if the law is in conflict with the provisions of Part 3 of the Constitution of India, that is fundamental right, it conflicts with or opposed to Part 3 of the Constitution of India to the extent of such inconsistency. That is, if it is inconsistent with the Part 3 of the Constitution of India, to the extent of such inconsistency, it is void. The law is void. So such argument was also advanced before the Supreme Court. The law, that is the law which prohibits Hindus in Bombay presidency from contracting second marriage, is opposed to Part 3 of the Constitution of India, that is Article 14, 15. There is a discrimination on the basis of religion. You might be knowing, you see Article 15, there shall not be discrimination on the basis of religion, race, caste, sex or residence. Under Article 15 Clause 1 of the Constitution, there cannot be any discrimination. But this act discriminates between the Hindus and Muslims, and therefore it is void and it is inconsistent. To the extent of that inconsistency, it is void. That was the arguments put forth before the Bombay High Court. That, however, the act was held valid. For the first time, Bombay High Court has held personal law, and so far as applicability of personal law to Muslims, which allow a Muslim to have second marriage when the first marriage was subsisting, is not a law within the meaning of Article 13 Clause 1 of the Constitution of India. That was the first time the Bombay High Court has held personal law is not a law within the meaning of Article 13 Clause 1. If it is a law within the meaning of Article 30 Clause 1, then there was a discrimination. It is violative of Article 15 Clause 1. In such a case, to that extent of inconsistency, the act would have become void. But the Bombay High Court has held that is not the law. Personal law is not a law, and therefore it is not void according to the Supreme Court. That was the judgment was followed by the Supreme Court. That was also considered by the Supreme Court in so many cases in the later, even till Sabarimala case, that is Indian Young Lawyers Association case, that is Sabarimala case, Sayara Banu case, that is Triple Talaq case, those judgments have been considered. Even in Sayara Banu case, Justice Nariman, he has observed that order passed by the Bombay High Court in this Narasu Appa Mali case. The case is Narasu Appa, I can also tell the citation, State of Bombay versus Narasu Appa Mali. There is a case where the Bombay High Court has decided the issue. State of Bombay versus Narasu Appa Mali, that was reported in AR 1952 Bombay 84, page 84. Justice Nariman has said that requires reconsideration. That has to be, that requires re-examination. Judgment rendered by Bombay High Court in Narasu Appa Mali, holding that personal law is not a law. Even Justice Chandrachud, writing for the judgment in Sabarimala case, Indian Young Lawyers Association case, he has also said that judgment requires reconsideration, but not overruled. They expressed, the expression was to the effect that it requires re-examination. That is the position of law in so far as Narasu Appa Mali case. Then the Bombay High Court, the division bench of the Bombay High Court has said, referring to Article 44, for the first time Article 44 has also came up for consideration before the Bombay High Court. The Bombay High Court has said, so far as enactment of Common Civil Code under Article 44, the Britishers have not done it because it was not such an easy to enact uniform civil code for all citizens irrespective of religion. That was the reason why the Britishers have not enacted a uniform civil code and allowed the people to follow their own personal laws. And the reference was made by the division bench of the court. That was the first judgment. Coming to the Supreme Court, the the Article 44 was not the subject matter of discussion thereafter, till the Supreme Court has decided the case under 125 CRPC. You all know Shabanu case, Shabanu Begum. Muhammad Ahmad Khan versus Shabanu Begum case, that was reported in 1985, 2 SEC, page 556. 1985, 2 SEC, page 556. Constitution bench. The issue before the Supreme Court was whether 125 CRPC, which contemplates the maintenance to the wife by the husband, whether 125 CRPC will apply to Muslims. That was the issue before the court, whether 125 CRPC will apply to all citizens irrespective of the religion. The Supreme Court has considered it. The Supreme Court has said, relying on, they have not just, they didn't say that they are overruling the personal law. They are superseding the personal law. They only interpreted the personal law. According to Muslim Shariat law, a Muslim husband is to maintain the wife during the period of iddat. The iddat period is 3 months in case of divorce. That is what Holy Quran says. Constitution bench has interpreted the personal law, stating the personal law does not contemplate the situation does not contemplate the situation where the wife is unable to maintain herself after the period of iddah. During the period of iddah, husband is bound to maintain the wife, the divorced wife. What was the situation where she unable to maintain after the period of iddah? Such a situation is not contemplated under the personal law, and therefore our interpretation is, and if she unable to maintain herself after the period of iddah, in such a case the husband is bound to maintain the wife, and therefore 125 CRPC will apply to all citizens irrespective of the religion. This was the judgment rendered by the Supreme Court without overruling the personal law. In effect, personal law is superseded. However, according to the Supreme Court, they are not superseding this personal law. They are only interpreting the personal law. And some situation, some contingency has not been contemplated. Such situation has not been foreseen. In such a case, this will apply. That is what the Supreme Court has said. The judgment of Supreme Court in Sabonu case has raised controversy. There was an unrest among the Muslims. So procession against the government and the court in Mumbai and most of the cities, claiming that it intruded into the personal laws, and they opposed the judgment rendered by the Supreme Court and the government. When Rajiv Gandhi, then Prime Minister, was in power, he enacted an act called the Muslim Protection on Diverse Muslim Women Protection on Diverse Act 1986. The Muslim Women Protection on Diverse Act 1986. According to that act, a Muslim husband is bound to maintain her wife during the period of iddah, and after the period of iddah, her blood relative, namely father if any, brother or sister or near relative, are bound to maintain, supposed to maintain the divorced wife. If the father or brother or other relatives are unable to maintain, or not in a position to maintain the divorced wife, in such a case the concerned state work board should maintain by providing maintenance according to this act, 1986 act. This act was put on challenge before the Supreme Court of India in Daniel Latif case, claiming that it nullified the judgment of the Supreme Court, and it also offended Article 14-15. I can give you the citation in Daniel Latif case. That was also the Constitution bench, because if you see under Article 143, if any interpretation is to be made to the Constitution of India in a case, it should go before the Constitution bench. In so many cases, even to avoid the bench, contention is taken before the Supreme Court. It involves interpretation of the provisions of the Constitution, and therefore under Article 143 you will have to refer the matter to the Constitution bench. In most of the cases the Supreme Court has refused. Even in the recent hijab case, this contention was also raised before the two judges bench, that is Gupta, Hemant Gupta, and one more Rishikesh Rai, and that was turned down by Justice Hemant Gupta. Contention before the court is this involves interpretation of provisions of the Constitution, whether Article 21, Article 25, right to freedom of religion, whether it involves interpretation of Article 25, whether this wearing of hijab is a religious practice, fall under the right guaranteed under Article 25 of the Constitution of India, and therefore the request was made before the bench to refer the matter to the Constitution bench in the light of Article 143, but that was turned down. Then in Daniel Latif case, the Supreme Court has considered the Act 1986 Act. Ultimately, Supreme Court has upheld the Act. The Supreme Court has upheld the Act, and there also the Supreme Court has not superseded the personal law, and they interpreted the provisions under the 1986 Act. In 1986 Act, husband is bound to provide a reasonable and fair provision and maintenance. A reasonable, fair provision and maintenance. That is the word employed under 1986 Act. That was interpreted by the Supreme Court in Daniel Latif case to the effect that a reasonable, fair provision and maintenance would indicate wife's fair provision should be of such an amount. It will have an effect of maintaining the divorced wife even after the period of iddah. That was the interpretation made by the Supreme Court. That fair provision, that is why the fair provision, it is not a meager amount. The amount of maintenance that can be awarded under 1986 Act to the divorced Muslim wife would be that the Muslim divorced wife will be in a position to maintain herself from and out of that amount, fair provision, even after the period of iddah. That was the interpretation made by the Supreme Court, and therefore they upheld the Act, upheld the validity of Act, wherein also they have considered the enactment of Article 44, enactment of Common Civil Code in the light of Article 44. And we all know the courts cannot legislate. The duty of the court is only to see whether the laws enacted by the legislature, namely Parliament or the state legislature, is valid within the four corners of the Constitution, whether it is violative of the provisions of the Constitution, whether it is violative of Part 3 of the Constitution. That is the duty of the state. It will have a judicial review over the laws enacted by the legislature. It cannot issue any direction to the government to legislate. Such power is not available. We know the three watertight compartments in the Constitution: executive, legislature and judiciary. Each one will have their powers in their own spheres. The power available to the executive or legislature or judiciary cannot be encroached by one organ, other organ. They are allowed to exercise their rights and duties within the framework of the Constitution of India, and therefore the duty to legislate, the right to legislate, is conferred only on the legislature, Parliament or the state legislature. What the courts can do is, they can only express it is desirable for the enactment of a legislation, but it is for the state to consider whether the legislature can enact certain laws or not. It is for the state to consider. It is for the Parliament or the state legislature to enact law. But here also they expressed the enactment of Uniform Civil Code applicable to all citizens to avoid all these big things in Daniel Latif case. And they have also compared the laws, Hindu law and Muslim laws. And thereafter there was a judgment by the Supreme Court in Jordan Dengede versus S.S. Chopra, that was reported in 1985, 3 SEC, page 62. Judgment rendered by Justice Chinnappa J, where there was no provision for the Christians to dissolve the marriage by mutual consent. And after this judgment, amendment was made, inserting section 10A to the Divorce Act 1869, making a provision for dissolution of marriage by consent. And when the judgment was rendered by the Supreme Court, there was no such for dissolution of marriage by consent. That was considered by Supreme Court. They have considered the various laws to hold that there is a disparity among the legislations applicable for the subjects, Hindus, Muslims, Christians, and they express that there shall be an uniform civil code if enacted would resolve the issue. And resolve the issue. That was the decision rendered by the Supreme Court. Then thereafter, in 1995, a judgment of the Supreme Court stirred a controversy. Judgment rendered by Justice Kuldeep Singh, the then judge of the Supreme Court, in the judgment reported in Sarla Mudgal. Sarla Mudgal, it's a famous case, Sarla Mudgal versus Union of India. That is reported in 1995 3 SEC. 1995 3 SEC, page 635. The issue before the Supreme Court was a Hindu husband converted to Islam, contracted second marriage when the first wife was alive. That was the issue before the court. What would be the effect of the second marriage? The Supreme Court has said, Justice Kuldeep Singh has held the second marriage, the Hindu convert to Islam and contracting the second marriage is void according to the Supreme Court, because the intention of conversion is the marriage and therefore it is void. Nothing wrong in rendering such proposition. Justice Kuldeep Singh has gone a step further and he has observed in his judgment, after the independence, Hindus joining along with Sikhs, Jains, Buddhists. You might be knowing Jains, Buddhists and Sikhs are also treated as Hindus for the purpose of legislation. Only Hindu Marriage Act will apply for all Sikhs, Jains and Buddhists. He observed Hindus joining along with Jains, Sikhs and Buddhists forsaken their interest for the national unity and integrity. But some other communities are not. The wording employed by them for maintaining the national unity and integrity, they have given up their interest for the national unity and integrity, whereas other communities are not. And therefore what he said was, he directed the central government to file an affidavit through a proper and a responsible officer in the cabinet rank for the enactment of common civil code, uniform civil code applicable for all citizens irrespective of the religion. This observation by the court was met with serious criticism, not only among the politicians but also among the members of other community. But there was hue and cry against this judgment, and there were in so many forums this judgment was debated, and the judgment of the Supreme Court was criticized by intellectuals also. This made Justice Kuldeep Singh to clarify later that the observation made by him is only an obiter dictum and it's not a ratio decidendi. Earlier he said a responsible officer from the central government should file an affidavit for the enactment of the steps taken by the central government for the enactment of common civil code, and later it was clarified by him because of the opposition from various quarters that it can be considered only as an obiter dictum and it is not binding and it is not a ratio decidendi. That is what in Sarla Mudgal case the Supreme Court has held. And later in Lily Thomas case, Lily Thomas versus Union of India, there was reported in 2006 SEC page 224. Here also the convert from Hindus married for the second time. The Supreme Court has followed Sarla Mudgal case to hold that such second marriage is void and it is not valid in law. And the Supreme Court has also considered the Article 14 enactment of Article 14. They expressed the having uniform civil code for all the people. And thereafter in 2003 in John Vallamotam versus Union of India, that is reported in 2003 6 SEC page 611. 3 judges bench, issue before the court was the validity of section 118 of Indian Succession Act. Section 118 of Indian Succession Act prohibits Christians from donating the properties in favor of the charitable trust or other organizations when the nephew, niece or other relatives are alive, except that such will should be executed a year before his death, and such will should be deposited with the concerned person within 6 months of such execution. Though others who fall under the other faith are entitled to execute will, namely Hindus, are entitled to execute will at any time before death. This 118 prohibits the Christians from executing will in favor of some charitable organizations when their relatives are alive within 1 year of their death. So this came up for consideration before the Supreme Court. The Supreme Court has struck down section 118 of the Indian Succession Act, and has also had a word about enactment of Uniform Civil Code in the light of Article 44 of the Constitution of India. Then Sabnam Hasmi in 2014, that is Sabnam Hasmi case, Sabnam Hasmi versus Union of India, that is reported in 2014 4 SEC page 1. In that judgment, the issue before the Supreme Court was whether Juvenile Justice Care and Protection Act 2000, we had 2000 Act earlier, now that 2000 Act is repealed by Juvenile Justice Care and Protection Act 2015. Now 2015 Act is in force. Earlier 2000 Act was an issue before the Supreme Court. Section 41 of Juvenile Justice Care and Protection Act 2000, which contemplates adoption can be made by one relative in favor of the other relative. It does not speak of any religion. The issue before the court was whether this provision, section 41 of the Juvenile Justice Act, which contemplates adoption by one relative in favor of the other relative, will apply to Muslims. I would like to tell you, Muslim Personal Law Shariat Application Act 1937, section 2 of the Act says, in respect of marriage, dower, divorce, interstate succession, inheritance, adoption, guardianship, personal law, Shariat will apply for Muslims under section 2 of Muslim Personal Law Shariat Application Act. In these subjects, Muslims are governed by the Shariat law, that is Quranic law. Shariat is nothing but Quran. What is given in the Quran is Shariat. So, in respect of these subjects, Muslim Personal Law Shariat Personal Law will apply for Muslims. So, this Juvenile Justice Act 2001, section 41 contemplate adoption by one relative in favor of the other relative. Will it apply to Muslims? The difference between Muslim personal law and the general adoption is, in case of adoption, you all know, once a child is adopted, the adopted child will become the child of the adopted father, and whatever the benefit a biological son or biological daughter will enjoy can be enjoyed by the adopted son or adopted daughter. They are entitled to inherit the property of adopted father, adopted mother, adopted parents under the common law of adoption. That is what Hindu Adoption and Maintenance Act 1956 and the Juvenile Justice Act also says. In so far as Muslim personal law is concerned, adoption is permissible. At the same time, the adopted child will not be entitled to inherit the property of the adoptive parents under Muslim personal law. Earlier, prior to Quran was revealed by God to Prophet through the angel, and prior to that there were large scale of adoption among the Muslims, and they treated adopted children as their own children, just like now. There were instances why a surah, an ayat has come. Ayat has come from God to the Prophet through the angel. The chapter is Al-Ahzab. If you happen to read verse number 4, 5 and 6, verse number 4, 5 and 6 in Al-Ahzab, there was a command of God in the Quran which says, don't treat the adopted son as your son. In Tamil, I used to read Quran in Tamil, which says, Nabi means prophet Muhammad sallallahu alaihi wasallam. நபியே, உறவுகள் நீங்களாக வைத்துக் கொள்வது அல்ல, உறவுகள் இறைவனால் ஏற்படுத்தப்பட்டது. நீங்களாக உறவுகளை வைத்துக் கொள்ளாதீர்கள், இறைவனால் ஏற்படுத்தப்பட்ட உறவுகளை சொல்லுங்கள். எதற்காக அதை சொல்றாங்க அப்படின்னு சொல்லி சொன்னதுல, Prophet Muhammad adopted a son, one Zaid. Zaid was the son of one Haris. Prophet Muhammad called him Zaid bin Muhammad. Zaid bin Muhammad means Muhammad bin Mahan Zaid. Muhammad Zaid உடைய உண்மையான அப்பா ஹாரிஸ். ஆனால் after adoption Prophet Muhammad called him Zaid bin Muhammad, முகமது உடைய மகன். அந்த நேரத்தில் தான் this verse has come from the God. Don't call by your relations, and the relations are created by God. And once this verse has come to Prophet, immediately he has changed the relationship. He called Zaid as Zaid bin Haris. Earlier he was called as Zaid bin Muhammad, and later Zaid bin Haris. This is the history of revelation of that surah, that ayat to the Prophet Muhammad in the Quran. And therefore, under Muslim personal law, there are shares prescribed for the relatives. In if you happen to read in Quran, in the second chapter, Al-Baqarah. Al-Baqarah means Pasu. Al-Baqarah and Al-Imran. Imran in Sandadigal. In 2 chapters 2 and 3, if you read, you can find this whatever you have seen in the Mullah's Muhammadan law, the tabular column, the shares of the descendants, and you can find there what is the share of wife, widow, what is the share of son, daughter, and you can father, and you can find everything in these 2 chapters. And therefore the adopted son are not entitled to inherit the property of the adoptive father under Muslim personal law. And therefore this issue had cropped up in the Supreme Court in Sabnam Hasmi case. Justice Sadasivam judgment, and he held this Juvenile Justice Act is a secular legislation, and therefore this act will apply to all citizens irrespective of the religion. And they have also held this is a small step towards the enactment of Uniform Civil Code. That is what they have observed in the judgment of the judgment in Sabnam Hasmi case. It's a small step towards the enactment of Uniform Civil Code, and therefore this Juvenile Justice Act will apply irrespective of the religion. And thereafter, Juvenile Justice Act, Juvenile Justice Care and Protection Act 2015 was enacted. Before Sabnam Hasmi, before the Supreme Court in Sabnam Hasmi case, Muslim Personal Law Board intervened by filing an application, and they have contested the case on the ground. There is a system called kafala system among the Muslims, where they can take adoption of the children and they can also maintain the children. just like their own child, they can maintain the children. Only thing is they are not entitled to inherit the property, that's all. But the rest of the right available to the adopted children are available under the kafala system. Once such system is available under the personal law, the enactment which encroaches upon the personal law may not be imposed on the Muslims. That was the argument advanced before the Supreme Court by Muslim Personal Law Board. That contention was rejected by Supreme Court in Sabana Wasmi case. And thereafter, once this government has come to power in 2014, new act was enacted, Juvenile Justice Care and Protection Act 2015. There is a provision under section 56 class 1. In 56 class 2, 56 class 1 speaks of adoption of child by one relative to another relative, and the class 2 says this adoption can be done by one relative in favor of the other relative irrespective of the religion. Irrespective of, earlier under section 41, the legislature was careful in employing the word irrespective of the religion has not been there under the original act, 2000 act. But in 2015 act, irrespective of the religion, adoption can be made. These are all certain things, certain advancement or something. It can be said that encroachment on the personal law by the legislature. Once 1937 act is in force, that is Muslim Personal Law Shariat Application Act 1937, which governs adoption also. This legislation which governs the personal law on adoption can be an encroachment, it can be argued, and still the act was enacted, that is in 2015, 56-1. Then I can take you to Sayara Bonu case. It's a triple talaq case, and it's rendered by Constitution Bench, that is reported in 2017 9 ACC page 1. The Constitution Bench in the 3:2 majority, minority judgments by Justice Abdul Nazir and Justice Kahar, then Chief Justice Justice Kahar and Abdul Nazir, and majority judgment rendered by Justice Kurian Joseph, Justice Nariman and Lalit. And they held the consideration before the court was whether the triple talaq at one instance is valid or not. The Supreme Court has held the issue before the Supreme Court in Sayara Bonu case also, the triple talaq forming part of the personal law. Once it is forming part of the personal law, can the Supreme Court hold that it is inoperative, inconsistent with Article 13 class 1 of the Constitution of India, because it is inconsistent with fundamental rights, part 3 of the Constitution of India. And therefore the Supreme Court has considered whether this personal law is a law within the meaning of Article 13 class 1 of the Constitution of India. Again, the judgment of Bombay High Court in Narasoppa Mali was also the subject matter of discussion by the Supreme Court. And Justice Nariman has said it requires re-examination. But the majority judgment has not touched the personal law, and they have only interpreted the personal law. According to the majority, they are not encroaching upon the personal law. They are only holding, considering Muslim Personal Law Shariat Application Act, which contemplates that which governs the marriage are governed by the personal law. So insofar as that provision, that is that legislation, that is Muslim Personal Law Shariat Application Act, which allow the Muslim husband to divorce by pronouncement of talaq at one instance, that is not valid according to the Supreme Court. They have only interpreted the Supreme Court. They have also considered Quran, the chapters Al-Baqarah, Al-Imran. I have said, if you happen to see this judgment, that verses in the Quran have been extracted by Justice Kurian Joseph, and there is another chapter called Al-Talaq. These 3 chapters have been extracted by Supreme Court to hold that the Quran does not contemplate pronouncement of talaq 3 times at a time, and they have interpreted the Quran to hold that only talaq-e-hasan and talaq-e-hasan are permissible, and the triple talaq at one instance is talaq-e-biddat. Biddat means it has come later, it was followed later, that is biddat, pinnadi ஏற்படுத்தப்பட்டது, that is biddat, that is not valid according to them, and they held that in case of talaq-e-hasan and hasan, there should be a prayer conciliation before pronouncement of the talaq. The parties should be represented by their own father or elders, and they should have taken effort for reunion in the conciliation. The conciliation would have been failed. Only in the event of failure of conciliation, if talaq was pronounced, and 2 kinds of talaq, pronouncing one talaq and waiting for a month. In the meantime, the parties can and if there was no reunion, they can pronounce the second talaq, and they can wait for another 1 month, they can reunite. If there was no reunion, then they can pronounce the third and last talaq. On pronouncement of last talaq, the marriage will come to an end, and there would be a prayer conciliation before pronouncement of the talaq. That is what the Supreme Court has held in Sayarabonu case, where the Supreme Court has also considered the uniform civil code for all citizens. And lastly, Supreme Court in Indian Young Lawyers Association case, that is Sabrimala case, has also considered the enactment of uniform civil code. It is only an observation by the Supreme Court, and to hold that the law applicable among the different subjects among the in civil law. These are all the role of judiciary right from the constitution of the courts after independence till date, and it is at this stage there are proposal for the enactment of uniform civil code. Earlier, the Law Commission under the chairmanship of Justice A.R. Laxmanan, the chairman of Law Commission of India, they have given a report. The report was to the effect that though they are in favor of the judgments rendered by the Supreme Court, in one of the case he was also a party. They are in agreement with the judgments rendered by the Supreme Court. The report says they are refrain from recommending or giving a report for the enactment of uniform civil code because it will invite adverse remarks from certain people, and therefore they have not made any recommendation for the enactment of uniform civil code insofar as that report by the Law Commission is concerned. Now let us come to this aspect. These are all the issues that was faced by the Supreme Court. Once it is the directive principles of state policy under Part 4 of the Constitution, the state is entitled to enact uniform civil code. Once the state has decided to enact uniform civil code, which law will they enact? Whether they will enact the law applicable for the Hindus, or law applicable for the Muslims, law applicable for the Christians or Parsis. These are the issues we may encounter. Even if you see, even as a student of law, we study among the Hindus, there are laws of Mitaksara followed by Hindus in the rest of the country, and in Bengal the laws of Dayabaga, that is followed by Hindus. And even under the Hindu Marriage Act, if you see, the customary marriage, customary divorce is also permissible under the Hindu Marriage Act. There is no uniformity even among one religion so far as civil law is concerned. There are different kinds of the marriage, different practice of divorce are practiced by practiced among the Hindus. Now, in such a situation, which law can be enacted as a common or uniform civil code? That would be the issue. If you see, you might be knowing Justice Kannan. Earlier he was appointed as Judge of Madras High Court. Later he was transferred to Punjab and Haryana High Court. His appointment was made, his appointment was opposed by none other than the then Chief Minister of Tamil Nadu, Dr. Kalaignar Karunanidhi. The reason was he was a member of RSS and he was an active member of the RSS, and therefore his elevation was opposed by the then Chief Minister. And the Chief Justice of India was Justice K.G. Balakrishnan. An agreement was, understanding was made between the Chief Justice of India and the then Chief Minister that he can be appointed here as Judge of Madras High Court, later he will be transferred somewhere. On such understanding his appointment was made. Later, after some few months here as Judge, he was also here adorning the Madurai bench. He was transferred to Punjab and Haryana High Court and retired. He was a very good judge. And after demitting his office in 2016, he wrote an article in the center page of Hindu. In the center page of Hindu in 2016, you could find, if you read, he has spoken of the Uniform Civil Code. If Uniform Civil Code is brought, according to him, he considers the succession, inheritance and marriage, divorce followed in the Muslim personal law should be made as laws. Uniform should be made as laws in the Uniform Civil Code. That is what he wrote in the Hindu center page. And now let us see, when India was given independence, there was an opposition from the Britishers for giving independence to India on the ground that the interest of the minorities will be at stake. They will not be secure. They will be insecure in the event of giving independence. That was one of the arguments advanced by the Britishers. In Sardar Vallabhbhai Patel, he was the chairman of Advisory Committee on Minorities. In 1947, he has made a speech. Just I would like to read it. It was incorporated by Supreme Court in Ahmedabad St. Xavier's College case. This was also, I have argued this, quoting this his speech in the assembly. I argued before the Supreme Court in the judgment reported in 2014 8 ACC page 1, that is Paramati Educational and Charitable Trust, challenging the Right to Education Act. Number of writ petitions came to be filed before the Supreme Court of India. Writ petitions by the non-minority institution. Number of institutions by the non-minority institution, only one writ petition filed through me by a minority institution. In that case, my writ petition was allowed, holding that Right to Education Act is ultra vires of Article 30 Clause 1 of the Constitution of India, and Right to Education Act was held to be valid and intra vires insofar as non-minority institution is concerned, according to Supreme Court. That is reported in 2014 8 ACC page 1. This is a judgment rendered by the Constitution bench, where I relied on this. I argued quoting the speech of Sardar Vallabhbhai Patel, and I would like to read it. That is that is extracted in Allahabad St. Xavier's College case, reported in AIR 1974 page 1389. He said, that was on February 27, 1947. Gentlemen, I thank you most sincerely for the honor, the great honor that you have conferred upon me by reposing your confidence in electing me as chairman of a committee which is composed of various interests. The committee forms one of the most vital parts of the Constituent Assembly, and one of the most difficult tasks that has to be done by us is the work of this committee. Often you must have had in various debates in British Parliament that have been held on the question recently and before, when it has been claimed on behalf of the British government that they have a special responsibility, a special obligation for the protection of the interest of minorities. They claim to have more special they claim to have more special interest than we have. It is for us to prove that it is a bogus claim, a false claim, and that nobody can be more interested than us in India in protection of our minorities. Our mission is to satisfy every one of them, and we hope we shall be able to satisfy every interest and safeguard the interest of all the minorities to their satisfaction. This was the speech rendered by Sardar Vallabhbhai Patel in the advisory committee on the Constituent Assembly on minorities, and an undertaking, solemn undertaking was given by the chairman of the advisory committee that it is for us to protect the interest of the minorities, and the claim of the Britishers that was made in the parliament and somewhere else is a bogus or false claim. That was the undertaking given, and therefore it is at this stage, is it necessary for the enactment of uniform civil code? That could be seen when as I said in paragraph 158 of judgment of the Supreme Court in TMA Pai Foundation case, the composition of India, different religion, different faith, different language, and therefore we proud to say that India, we are in unity in diversity. That is the proud of India. In such a case, when there is no issue, when there is no problem, when there is nobody is aggrieved, is it necessary for the enactment of uniform civil code? And the issue of enactment of uniform civil code is raised now for some political reasons. If you, I can take you the words of Franklin Roosevelt. Franklin Roosevelt has said, in a democratic country, the democracy will survive so long as the state recognizes the interest of minorities. That is what Franklin Roosevelt, the then American president, has said. The democracy in a country will survive only if the state recognizes the interest of the minorities. Once that has not been recognized, then there will be a disharmony in the state. India cannot be compared with the other state, a monogeneous state like Pakistan, Indonesia, or England, or America. And the India is a combination of all languages, religion, culture, various factors, and therefore to maintain social communal harmony, it is always desirable to allow the people to live in peace, and to follow their own faith and to follow their own personal laws. That would be in the interest of the nation. That is what I feel. It is only a debate. It is only my personal view, and you may have your own view. Don't get offended if I express my personal view. That's all, and I leave it to you to decide whether enactment of uniform civil code is required in the present circumstances or not. And thank you for the opportunity given to me to join with you on this debate. Though the debate is somewhat serious and something controversy, and we are debating the issue only intellectually to share our views. That's all. Thank you.
Graduate is the completion of thankfulness. Now I request Mr. R. Karnadidi, MBHA Orientation Committee Coordinator, vote of thanks.
Dear friends, let us give a big clap to our senior counsel. It's our time to express our gratitude to senior counsel and others. I thank Mr. President ANDIRAJ sir, Mr. Secretary ANBARASU sir, Joint Secretary Petraj sir, and other coordination committee, and especially the chairman of this orientation committee, ALAGUMANI sir. Ajmal sir is always close to our heart of MBHA, as said by our president. Our senior counsel has started with TMA Pai Foundation case and ended with Sakira Banu case. We understand how much pain he has taken to note down all the citations and preparing for exploring the issue before this forum, and especially he narrated what was transpired from the Constitution Committee, Standing Committee, Subcommittee, and the impact of the judgments rendered by including Justice Kuldeep Singh and others. It was a very spark and spontaneous speech. I thank you, Mr. Senior Counsel, and also I got the point that when Sir spoke about Article 44, earlier also myself was thinking about that it was a state duty to enact it, but Sir explored that specifically that it is an endeavor by the duty of a welfare state to make that law. And I would conclude with that what Mahatma Gandhi said. Mahatma Gandhi has said, I don't expect India of my dreams to develop one religion, that is wholly Hindu, wholly Christian, wholly Muslim. He wanted the India to be the whole tolerant country, to accept all the religious and all the caste in respect of without any discrimination. I thank one and all who gathered here to complete this session in very meaningful manner. Thank you.